Yeah, I wanted to talk a bit about border procedures because that is what I did research about together with my colleague Galina Cornelissen. Um, so when you talk about border procedures, I'm meaning proceedings in which the admissibility or the substance of an asylum application is assessed before a decision is taken on entry of a person to the territory of the European Union or a member state. And this procedure usually involves detention. Um, so I will share some of our research findings. We wrote, as Janna already said, we wrote a report for the European Parliament about the transposition of border procedures and the application of border procedures in the member states. And we also looked at the new EU proposals and the role of the Commission in the development of those proposals. And I will share some of these findings and of course link them to the global compacts. But I have to admit that with regard to the GCM, I'm completely new because it was actually for this presentation the first time that I had a look at it. Well, that is telling for me as a person, maybe, that I didn't look at it before. But I think it's also telling about, you know, the fact that we didn't even encounter much references to it in all the documents that we read about border proceedings, that we didn't see much references in the EU proposals, as was said before as well, but also that the compact is quite absent in the Dutch debate about migration. I think that is also something that is telling. So it's not only, probably not only my fault. So if you could go to the next slide. Well, of course, if you look at the GCM, it's mostly article of objective 13 that is relevant. So Janna already mentioned it. Migration detention should only be used as a measure of last resort, and alternatives should be used. And there should be a legal basis. It should be have a legitimate aim. There should be a proportionality test. It must be an individual assessment, and there should be procedural safeguards, due process. So that is the key objective of the GCM. But next to that, I think that also especially in the context of border proceedings, objective 1 is relevant as well, which is the one which mentions that policy should be evidence-based and that there should be effective monitoring and evaluation. Because we found in our research that particularly that is lacking when we're talking about border procedures. So maybe you could go to the next one. If you look at EU law, border proceedings are currently based on Article 43 of the Asylum Procedures Directive, which provides for a border procedure that lasts maximum of 4 weeks. And during this procedure, member states can assess the admissibility as well as the substance of an asylum claim before the decision on entry is taken. The EU proposals foresee a kind of an extension of border procedures towards a screening procedure before, well, at the moment a person tries to enter the EU member state. And then persons seeking international protection can be transferred to a border procedure. And if they are rejected, they can be put in a return border procedure. So you see that something will come before and after the current border procedure. The next one. What we saw while doing research is that there's a lack of information about what is currently happening in the member states with regard to border procedures. So the European Commission is now claiming that this new border procedure is a solution to part of the problems of the asylum system in Europe. It is claiming that the system as it is doesn't work anymore, and that the new border procedure is one of the things that should change this situation. But what we've seen is that there is a complete lack of evidence on which this claim is based. So the Commission has not published any evaluation, for example, of border procedures, but also asylum procedures directive in general, but also border procedures specifically. So we don't know much about how it works in the member states. There's no impact assessment. There's a complete lack of data, for example, on how long and how often detention is applied in border procedures, but also if any alternatives are applied by the member states. There's no evidence of that it happens. And there is insufficient monitoring. So there is no, EASO did a report, for example, on border procedures, but it was very much following what member states themselves reported about whether they have border procedures in their under national law, for example, and not a critical monitoring of all the procedures in place. And what we've seen in our research is that there are many problems with regard to the uniform application of border procedures, but also with regard to fundamental rights of people whose applications are processed in border procedures. First of all, there is wild-scale de facto detention. So that means detention without any legal basis under national law. Many member states say we don't have a border procedure, even though they do have procedures in place, for example, assessing asylum claims while people are staying in transit zones, but they don't call it a border procedure under national law. And you can see that there is a lot of unclarity where it comes to the distinction between, on the one hand, detention, which is, of course, combined with a lot of procedural guarantees, and freedom and restrictions of freedom of movement on the other hand. So a lot of people stay in a kind of situation in which it is not clear whether it is in fact detention, and where no decisions are taken or remedies are available. So that also means that there's a lack of control on these kind of practices. And you can see in the EU proposals that this situation will not change, because the proposal itself is very unclear about whether a border procedure generally involves detention or not. Secondly, border procedures are applied systematically. So that means that a lot of member states just channel everybody who applies for asylum in a border procedure, if the claim is done at the border, of course. Some states do a pre-screening, but there are also a lot of member states that say, well, we need to put people in border procedures which involve detention, because otherwise we cannot exercise border control. And that includes even people with high chances of success for international protection. So we see that there is no proportionality assessment, no assessment of individual circumstances, such as vulnerable asylum applicants. And we didn't find any examples of alternatives to detention in case of border procedures. And finally, you also see that quite a few member states apply border procedures to unaccompanied children or children and families. In the EU proposals, you see that the border application of the border procedure will even become mandatory in some instances, and that still it's allowed to apply border procedures to children as well. Okay, next one. Yeah, finally, I wanted to say something about the combination of detention and the asylum procedure, because of course, a border procedure is about the admissibility or even the substance of an asylum claim. And there we see that the combination of detention and very short time limits is very problematic. Of course, the longer the asylum procedure takes, the longer the detention also will take. So there's a tension there, right? But that also means that a lot of member states apply a border procedure with very, very short time limits. And the fact that people are detained, do not have contact with the outside world, makes it very hard for them to prepare and substantiate their asylum claim. And we saw that in practice, many people do not have access to information, to legal assistance, just because they are not able, for example, to contact people in the outside world in the member state to help them. Also here in the EU proposals, there are not really solutions to this, to the factual accessibility, for example, of legal assistance or information. And there is no minimum time frame. So member states are still free to apply very short border procedures. The next one. Thanks. So then, of course, I had to think a bit about what the GCM can do here. And first of all, I thought, most of the standards that are in the Objective 13 are also standards that are common in EU law. So, of course, EU law also requires a legal basis for detention. It requires proportionality tests. There are provisions about alternatives, etc. The better regulation guidelines require the Commission to base its proposals on evidence. So it's not that in that sense that the GCM is bringing something new, but I did think that the proposed actions that are mentioned in the GCM could be very relevant and might help maybe the European Parliament, who did refer to the GCM, by the way, in its proposed resolution about the border procedure, to stress the responsibility of the Commission to arrange proper monitoring and evaluation, but also to make maybe not only European institutions and member states, but also civil society think about alternatives to detention, specifically in the context of border procedures, because that is something that is currently still lacking, I think. There's not a lot of research done about alternatives in the context of border detention. And then finally, advocating for factual accessibility of procedural rights, for example, is definitely something that should be done as well. So I just picked out a few points. I hope that is useful for the further discussion. If you want any further information, these are the links to the report we wrote, as well as the article about the role of the Commission in the proposals, the development of the proposals about border detention and border procedures. Thank you very much.